According to Section 16 of Advocates Act 1961, it recognizes two classes of advocates. One, the senior advocates. Second, the other advocates. However, the said act does not mention a special gown for senior advocates. Further, the Bar Council of India's rules are also silent on the issue of a distinct gown for the designated senior advocates, even though it does provide for different forms of dresses to be worn by advocates and lady advocates in court. Currently, the tradition is that a designated senior advocate wears a gown with a flap at the back, unlike the gown worn by a non-designated senior advocate. The so-called senior's gown has become a symbol of discrimination in the courts, particularly from the bar side when they face the bench, because the symbol of discrimination due to senior's gown is based on an arbitrary practice and ends up distinguishing ranks of advocates from the others. This kind of practice, particularly when India is celebrating Azadi Ka Amrit Mahotsav, commemorating 75th annual independence celebrations happening during this year. Particularly when India was celebrating its 70th Independence Day, a senior counsel, a senior advocate by name Miss Indira Jaising, took the call of gown wapsi movement. 3 decades ago, Miss Jaising had become the first woman to be designated senior advocate by the Bombay High Court. She has been a pioneer and a leader of the feminist movement in India and has advocated fiercely for protecting the rights of women by challenging the discriminatory personal laws and defending survivors of sexual violence. Now, after 4 decades of her service to the bar, when India was celebrating its 70th Independence Day, she has taken the decision to shed the gown of a senior advocate that, according to her, was no longer a professional gown but a commercial gown. That was her perception when India was celebrating 70th Independence Day. But when India is celebrating 75th annual Independence Day celebrations, I feel that the time has come where one universal form of dress code should be equally applicable to all the people practicing at the bar in front of the bench, because the practice of wearing different gown is a direct inheritance from the English to distinguish advocates of different ranks. It is similar to the practice of addressing judges as lords and ladies, and to date advocates have continued to don a different gown to distinguish a senior from a junior. It has been 75 years since independence. Parliamentarians have been debating on the issue since the Quit India movement, and yet we in the legal profession are aping the British attire and the behavior inherited from them. Currently, the basis of designating a senior is experience and standing at the bar, or special knowledge or experience in law. There are many pathways to become a senior advocate. For becoming a senior advocate, either one should have the experience and standing at the bar, or special knowledge, or experience in law. So these 3 abstract, ambiguous routes to become a senior advocate are currently misused in a democratic setup like India for a long time, because the process of designation being extremely subjective, it is an opaque method which is susceptible to misuse, as it can be discriminatory tool to favor the selected few advocates. Thus, the time has arisen to challenge the existing method of designating a senior in the Supreme Court or a senior in the High Court, seeking objective guidelines that will make the procedure transparent. As per bar and bench surveys, 75% of the survey participants feel that the designations are discriminatory and based on political ideology. And 74% of the participants also feel that discrimination was based on social status, gender, and religion. The junior advocates, usually a product of a competitive examination system, are dissatisfied with the subject to election of advocates at a rank above them. Because prior to 2011, there was no All India Bar Council examination for an advocate to get Sanat. Post 2011, one needs to qualify himself in All India Bar examination to get Sanat and to sign wakalat. Whereas the advocates whoever have enrolled prior to 2011, they did not face any bar examination, or they did not have any continuous development process hours allocated by them in a year for updating their knowledge. Simply the process followed the experience at the bar or the so-called special knowledge or experience at law as the criteria for designating a person as a senior. This process is highly discriminatory and can be challenged and can be proven scientifically too, because in the higher courts, particularly in the High Court and also in the Supreme Court, getting a hearing by a very bright and knowledgeable legal counsel is very difficult. But when you approach the bench with a person who wears a senior gown, it becomes so easy, because the judges tend to give them a considerate hearing. This kind of discrimination has to end. The senior gown as a rank has to be shunned for a more selection-based method which can lead to an equal level playing field. At the moment, comparatively, senior advocates charge higher fees than the non-designated ones and have a de facto monopoly at the bar. This unjust system is unfavorable to the talented young lawyers who could be equally qualified, if not more. And even the judges, while being so considerate for the so-called senior gown holders, must remember that even they were also practitioners before becoming judges at one point of time or the other, and that it was sheerly due to their luck or due to their proximity or due to their frequent appearance or due to their luck at bar in a few cases which has brought them to limelight and made them to the career whatever that they have been enjoying so far. Given that kind of scenario, even the bench and even the bar should be equitable in terms of receiving the young talent. If you don't nurture the young talent and make them as the future of India, from where can you bring the great luminaries in the legal field? The young talent at this point of time is discouraged substantially due to the discriminatory selection methods being followed by the bench for the selection of the senior gown personalities from among the individuals on the bar side. When we look at the practices in other Commonwealth countries, we need to adopt some of the best methods from those Commonwealth countries, and I feel a 100-point criteria for the court's consideration, which includes parameters such as number of years of practice, public interest lawyering, number of reported judgments, quality publications, other contributions, qualifications, and contribution to the public affairs, etc., needs to be considered in a systematic manner for designating a senior. But the current evaluation method, which is only based on the perspective of the bench or the judges, is a kind of formation when an advocate argues in his or her court. It is indeed a strange practice as compared to countries like the United States of America, where the advocates are not mandated to wear a gown but can appear before the judge in a professional suit. The need of a gown itself is questioned by some legal practitioners, considering that the black gown was adopted as a token of public mourning on the death of Queen Mary. Needless to say, it will not stand the test of relevance today. While youngsters like me will always challenge the procedure of designation as senior advocate. But before a policy decision is taken on this front, in the meanwhile, the rank distinction which even mentally getting formed on the part of the bench while hearing the cases should at least be impartial in terms of delivering a fair judgment, because law does see law, but it doesn't see the gown. Whether the gown has a flap in the back or not is not the criteria for a judge to deliver judgment, and it should be in the interests of justice. Thank you very much.